to give away the welcome address.
Welcome everyone. Thank you, Krishna Kumar. Thank you for joining us for today's webinar. I am Dr. Arun Vasantagiran, Head Department of Mechanical Engineering, St.JOSEPH'S Institute of Technology, OMR, Chennai, one of the reputed engineering institutions in Tamil Nadu. It's my honor to represent St. Joseph's in its 26th year, which has a dynamic chairman, Dr. V. Babu Manoharan, under whose guidance we all excel. Always with us, our beloved Managing Director, Mrs. Jessie Priya, and beloved Director, Mr. Sashi Sekhar, whom's progressive ideas guiding us to achieve more. I wish to take this opportunity to thank our beloved Principal, Dr. P. Ravichandran, for his continuous motivation and support. Today's webinar is in the title, Invention to Patent, Awareness and Strategies, presented by Mr. J. Saurirajan, Registered Indian Patent Agent, and Mrs. Santi Lakshmi, Intellectual Property Right Consultant and Psychologist. Welcome, sir. Welcome, ma'am. Intellectual property. Intellectual property is a term referring to a brand, invention, design, or other kind of creation which a person or business has legal rights over. Almost all businesses own some form of IP, which could be a business asset. Common types of IP include copyright, patents, designs, and trademarks. As far as this particular webinar is concerned, we'll be going in depth regarding the patents. Patents, this protects commercial inventions. For example, new business product or process. India's Patents Act of 1970, 2003 patent rules, and 2016 patent amendment rules set out the law concerning patents. The regulatory authority for patents is the patent registrar under the office of the Controller General of Patents, Designs and Trademarks, which is part of India's Ministry of Commerce and Industry. The patent rights can be enforced only after securing the patent. Patent restricts others to make, use, offer for sale, or import the patented product. Patent is granted for both a product and a process. Patent right locks the functionality aspect and restricts the rights to the patent owner. Patent is a time-limited monopoly which is granted from the date of the first filing for 20 years. India's patent law operates under the first to file principle. That is, if two people apply for a patent on an identical invention, the first one to file the application will be awarded the patent. Hope this webinar throws lights on awareness and strategies on invention to patents. I hope you all will enjoy the upcoming session with us. On behalf of St. Joseph's Department of Mechanical Engineering and our webinar team, I warmly welcome you all again. Thank you.
Thank you, sir. Now I call upon Mr. R. Ranjit Kumar, Assistant Professor, Department of Mechanical Engineering, to give away the introductory address of today's speaker.
Thank you, Krishna. A very warm good morning to all who have taken our call to be a part of this webinar. I welcome you all and wish you a happy day. The informational access to the masses are ever on the rise. The more the information and more the domain knowledge, and the inherent ingenuity tends to invent, perhaps to innovate. We could see a lot of ideas pouring in from these younger generations of technocrats, they just end as an academic requirement. Somehow, we fail to cultivate the culture of registering and protecting those ideas and converting into an useful application later on. The very idea is to register your brainchild, which would grow as a greater personality to serve mankind. Protecting your intellectual property is not only your right, but also ignites your aspiration to grow, probably as an entrepreneur or as a researcher of great reverence. On a lighter note, I would say the entire life on the planet, in a way, is patented one. Each one of us got registered and registering without our knowledge. You know how? It has been in our DNA. Today, we have two eminent personalities to guide us and carry us along the labyrinth of IPR procedures and the nuances of getting into it. Behavior differs from person to person. Being normal is more easily relatable, but being abnormal requires deep investigation. When putting both together, you need someone with extraterrestrial intelligence to understand and analyze. Today, our predominant speaker, Mrs. Shanti Lakshmi, is one such personality who holds the key to open human minds, and the key being her master degree, MSc Psychology. Speaking of women's empowerment, that is more often quoted nowadays, has been proven for its existence way long back when Madam started her career at 2003 as trademark assistant in Mohan Associates and been there for 13 years. Later, Madam became admin head and technical consultant at Lee Intelligentsia for 2 years. Now, Madam is currently associated with All You Need as associate come IPR consultant and psychologist. We are happy to have you, ma'am. We also have one more intelligent speaker, Mr. Sauri Rajan, who has acquired his bachelor degree in the field of electronics and communication engineering and started his career as lecturer at Arur and Polytechnic in the year 2009 and remained there for 2 years. Then he became patent technical assistant engineer and patent analyst at Mohan Associate in the year 2012 and served them for 6 years. Currently, he is associated with All You Need as patent agent who gives patent technical consultation and in charge for filing patent application and prosecution. Happy to have you, sir. Without further delay, I would like to hand over the session to the two eminent speakers. I also thank our beloved HOD for giving me this opportunity. Thank you all.
Thank you, Ranjit Kumar sir. Shanti Lakshmi ma'am, you can take over the session. Participants, please mute your audio and video to view the seamless streaming of the presentation. If you are on your video, then there will be a lag of presentation if you have poor internet connectivity. And also, I request all the participants to pin Shanti Lakshmi G. Iyer presentation screen from the people list. Go to the name series of S. You can locate the ma'am. Please pin the ma'am's presentation screen to view the presentation. If your participants have any technical issues or any audio issues, please leave your post and queries in the chat box. We will dare to assist you. Please do not interrupt the session in between. And also, at the end of the session, we will post a certificate registration form. Filling upon this, we will get your certificate within 2 days. Yes, ma'am, you can take over the session.
Okay, thank you, Krishna Kumar, and thanks a lot, Ranjit sir, for a warm welcome. Very good morning to one and all. First and foremost, my sincere gratitude to God, the Almighty, blessing us all with this wonderful day. Secondly, my heartfelt thanks to the management of St. Joseph's Group of Institutions for giving me this great opportunity to be present here, especially to Dr. Babu Manoharan, Chairman, Dr. Ravichandran, Principal, Mrs. Jessie Priya, Managing Director, Mr. Shashi Shekhar, Director, and the conveners, Dr. Arun Vasandageethan, Professor, Head, Department of Mechanical Engineering, Dr. Savitri, Professor, Head, Lab Affairs, Department of Mechanical Engineering. Thirdly, I'm so thankful to the great professors, lecturers, and non-teaching staffs, and of course, my dear students who are all presented here. Actually, this is my second session in the form of webinar. The first one was in the year of 2018. It gives me an immense pleasure to be here for the second time to present the webinar. I'm so honored and happy for that. Okay, let's move to today's topic. Invention to patent, awareness and strategies. But before entering into deep discussion, let me share a valuable information and the great difference between the two scientific legends. It's none other than Thomas Alva Edison versus Tesla. There was a war of currents in the 1880s between Edison and Tesla. But Edison won the war. How and why? It's because he was a great businessman. Though he is a genius, he was a great businessman. And he knew that how to use his invention productively and how to make money out of his invention. Whereas Tesla wasn't a great businessman. He was only concerned about the betterment of people's lives. And though he was a genius, he failed to protect himself and his inventions. This resulted to a very tragic end. Yes, he died penniless and nearly forgotten. We should avoid such tragic ends in our life. This shouldn't happen to any inventors in future. So I personally feel it's my social responsibility as an IPR consultant to create awareness, educate, and assist the needies at the right time for the right course of action. I'll move to the slides. What is IPR? That is intellectual property rights. It's a large legal field having important branches. So IPR is, we have to protect our brain products under IPR in appropriate categories. So we have here major branches: copyright, traditional knowledge, industrial design, patents, trademarks, and geographical indications. So here our major topic is patent. Patent is one of the major branches in the IPR. So patent is a legal document granted by the government to an inventor to exclude others from making, using, offering for sale, or selling the invention, and giving an inventor the exclusive right to make, use, and sell an invention for a specified number of years, that is for 20 years. Keep in mind that a patent does not give you the right to make your invention. It gives you the right to stop others from making your invention. So it is covered under the act called the Patents Act 1970, amended by Patents Act 2005. It extends to the whole of India. It shall come to force on such date as the central government may publish by notification in the official gazette. This is the act, and it has its own history way back in 1856. But here we just precise the act. Let's move to the next thing, that why it is important, why we have to protect our invention under patent. And it is very important why I shared the difference between Tesla and Thomas Alva Edison here, because of the commercialization. Invention alone is not enough, but we have to commercialize our product into the market, and we have to know the techniques for by making money out of our invention. That's why I shared the small information here in this topic. So you can commercialize your invention, that is, it can be assigned to potential buyers, and it can be transferred, that is, technology transferred to the other organizations, and it can be mentioned in the resume, which gives reputation, improve your success of getting the desired job. And you can apply for awards. It is sanctioned by state and central governments. So these are the added advantage for the protection of invention under the patent. Patent law, salient features. Both product and process patent provider. Term of patent 20 years. Examination on request. Both pre-grant and post-grant apposition. Fast track mechanism for disposal of appeals. Provision for protection of biodiversity and traditional knowledge. Publication of applications after 18 months with facility for early publication. And substantially reduced timelines. What is patentable? A patent describes an invention for which the inventor claims the exclusive right. Your invention should be novel and useful, non-obvious, pertains to patentable subject matter. These are the main criteria. It has to be meet the requirements of the Patent Act. It is the standard thing and it has to be meet. What is not patentable? Frivolous inventions. Inventions contrary to well-established natural laws, contrary to public order or morality, causes serious prejudice to health or human, animal, plant life or to the environment, mere discovery of a scientific principle or example Newton's law, formulation of an abstract theory or discovery of any living thing or discovery of non-living substance occurring in nature, mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way, mathematical methods, algorithms or computer program per se, computer program by itself or as a record on carrier, new calculating machine, combination of hardware and software is patentable. A literary, dramatic, musical or artistic work or any other aesthetic creation including cinematographic work and television productions. These subject matters fall under the copyright protection. Section 4. Inventions falling within Section 21 of the Atomic Energy 1962 are not patentable. Effect. Inventions relating to compounds of uranium, beryllium, thorium, plutonium, radium, graphite, lithium, and more as notified by central government from time to time. Why we are insisting you to file your invention? It is our fundamental right to protect our brain products under appropriate categories of IPR. So we have to file our paper first. Why? Publicly using or selling an invention more than 1 year prior to filing a patent application completely bars you from ever winning a patent on that invention. Although inventions can be described both in a paper and in an application for a patent application has particular timing requirements, gives the patent owner particular rights, and often has different goals. Possessing or holding a patent registration is an asset. So patent, publish and process rather than publish or perish. Remember, the clock starts ticking as soon as you start talking about your invention. It is very much important that you should not disclose your invention details in the public by way of publishing in the social medias, or even a chit chat with your friend in the restaurant is very dangerous. So please be careful and very cautious about disclosing your invention details in the public. Patent first, paper later. Why? To avoid scientific and financial hardship, file a patent application before you publish, speak about, or present your work, and before you apply for grants. By not filing a patent application, you can inadvertently lock your university out of potentially valuable money-spinning activities. Instead of spelling out of each and every detail of your research when giving presentations, consider using codes to describe your data or the conditions you used. Then only you can protect your inventions. Otherwise, someone else may steal your invention and they will file application in their name and all your effort will go on in a vain. So we have to avoid that. Filing your invention as a patent application and then publishing in a journal needn't mean double the work. All it takes is a little foresight, planning, and vigilance to have the best of both worlds: patent first, publish later. If not patented, what will happen if you do not protect your inventions? As I said, somebody else might patent them. Competitors will take advantage of your invention. Possibilities to license, sell, or transfer technology will be severely hindered. Time, effort, labor will be lost. Funders will be discouraged. An idea worth patenting should be novel, useful, and non-obvious. After a patent application is filed, it undergoes publication and an examination process. Here, we have an option to file fast-track application, in which the chances of getting grant is within 1 to 2 years of time. Here, I would like to mention, normally a patent application takes 4 to 6 years of time to reach the maturity as a grant or rejections. In a fast-track mode, the timeline is very much reduced. You will get a grant within 1 to 2 years of time. There are specific requirements for writing a patent application. Legalese language is often needed to describe the invention. Scope of the invention should be in broad, conceptual terms to help define the protection afforded by the patent. A patent practitioner's job is to ensure that the patent application described as complete and broad as possible, and that inventors understand what is being described and claimed. While the inventor is an expert in the technology, the patent practitioner puts the invention in the proper form. So that's why you need a genuine patent practitioner to draft your patent application. It is very important to have a great patent practitioner and a knowledgeable patent practitioner. So from hereafter, the next slides and the details about filing patent registration, patent application, and the types of specifications and the types of filing globally and filing processes and all the details will be explained by Sauri Rajan. So I ask Sauri to take it forward from here. Sauri, you can continue, ma.
Thank you, Shanti ma'am. So, esteemed managing director and directors of the institution, respected patron, convener, and principal, learned professor and lecturers, and respected guest of the day, Srimati Shantilakshmi madam, beloved student friends, I rather inventors of the future. First of all, I want to convey my heartfelt gratitude for one and all for having created a golden opportunity to me to deliver something which is a significant one that about the exciting. All of you know a patent is one of the branches of the intellectual properties, and there are many wings also, like trademark, designs, geographical indication and all. So I am very glad to appear before you, but my mind is thinking about the day of darkness. Like the pandemic suffering of corona makes all unhappy. We are all individually and collectively waging a perennial war against the spread of virus corona This situation is to call for hygienic adaptations to all. Even though the corona creates chaos and confusions, fearfulness and sleeplessness during day and night, but it kindles corona, stimulates the mankind, especially medicine, to prevent and to eradicate the viral disease. The world is now watching and expecting new medicines and methods. In this circumstance, the newly invented medicines are to be registered. Under Patent Act, which may vary from one country to another country. So what is patent and what are all the scopes and how the patent application is filed? These are all the questions before you. Let us have the next slide. Before drafting, conduct prior art search. So prior art is the thing which need to be first searched, because you have one idea which must be patented, but you are going to check whether that particular idea is available in the public domain or not. So what is the problems ought to be solved by the invention? It will give you the novelty portion of your invention. So what is the inventive step which involved in the invention? So these are all the points need to be covered by the prior art. So is the solution obvious? You know that the umbrella, which was already invented 100 years ago, by holding the umbrella in the reverse position, you can call it as a water saving duct or something. No, so it's kind of an obvious solution. So such type of idea are not patentable. So we should know what is patent and what is the invention which should be a patentable one. So ascertain the type of application, whether we can file complete specification or provisional to be filed. Decide the area of decide the area and nature of the protection, whether you want to protect your invention within India or in globally. So if you are filing the patent application in India, then it is called as ordinary application. If you are filing for a PCT, it is Paris Convention Treaty. It is a worldwide protection patent application. So there is no world patent, only patent application is worldwide applicable. So I'm moving to the next slide. Prior art search, the most important aspect of the patent. So what is prior art search? So prior art is any evidence that your invention is already known. So what is prior art? So while you are checking in the Google browser, you are going to check whether your invention is already covered in the public domain or not. An abandoned patent or failure patent or IEEE project papers, or your invention may be published in any newspaper, which are all coming into the picture. Because these are all the documents which are all available in the market or in the public domain, then it is called as prior art. So why do you need to check for prior art? Because we want to know that what is the inventive step we are having, what is the novelty in the invention, and to check the novelty of the invention, cost effective, time saving, eligibility for patency. If our invention is already available in market, then filing for a patent is time consuming as well as waste of cost. So why should you create a prior art? It is an intellectual property strategy. So I'm moving to the next slide. So I'm moving to the next slide. What is the purpose? So why do you need to find a prior art? So to avoid infringement. Infringement is such a thing that one invention may be patented by others. So you don't want to enter into a patent, then you must find the prior art. So in order to avoid the infringement, we have to search for the prior art. So next thing is the monitor patents in a given area of technology. So collectively, so there are 100 patents in a technology, then the starting point of the particular technology and to the end of the technology, we can see what is the latest update of in the particular technology. So in order to obtain those informations, we need to have a prior art. Monitor patents by a company, university, or an individual. So patenting by a company or an individual or university, so it will be applicable. So locating information on a specific patent, marketing analytics, statistics. So if there is a patent, you can find what is the market analysis of the particular product. You can compare the recent trends in the Android mobile phones with the old ones. So what is the analytics and how the people are going to buy a new product which is already having patent by branded companies like Nokia or iPhone, like that. Search for potential cooperating partners and licensors. So through licensor, you can have a business. So because the patent is as an asset, so it may be rendered to anybody. So the drafting procedure comes into picture. It requires high professional skill. A well-drafted application decides the fate of an invention, plays a vital role in the success of an invention. I'm moving to the next slide. Anatomy of a patent specification, more complicated unless you understand the basic structure as per IP. A typical patent specification has the following sections. Title of the invention. It should reflect the main art of the invention. It should be precise with respect to the invention. Field of the invention. You should describe the scope of the invention and subject matter should be crisp and clear. Background of the invention. It should describe what others have done in the field and what are all the problems not solved by the prior art work. So in order to fill the background of the invention, you need prior art. So before filing a patent, there is a step, prior art searching. So the next step, object of the invention should clearly reflect the advantages of the invention and should describe the solution. Statement of the invention, describe exact novel features of the invention and should clearly reflect the inventive feature of the invention over the existing one. So the statement of the invention here itself describes both the old inventions and the new inventions together. A summary of the invention describes a broad overview of the invention and provides structure of understanding the detailed description and claim section. A brief description of drawings, it should point out the reference numerals used in the drawings should be specific and the line drawings are allowed. The photographic or 3D images are not allowable in the patent. Detailed description of the invention. The detailed description describes in detail what the invention is, how it is made and used and should reflect the complete picture of the invention. Importantly, mainly the details of the invention, how it is to be performed. So performance is highly required. So for this, I want to explain something. We already know that the telephone, which is the instrument, was invented by Alexander Graham Bell, and another inventor is that Antonio Meucci. So Antonio Meucci, who was filed the patent application during examination period, Antonio Meucci was asked to explain his instrument. He tells that while you are speaking, your voice signals travels along the wire and the other side the people can hear. But the examiner asks again the question that how the voice signal is traveling along the wire. But Antonio was not answered properly. So that Alexander Graham Bell files the next patent application and he was awarded for the patent because he explained correctly that the voice signal is converted into electromagnetic signal. On the other side, again, the electromagnetic signal is converted into voice signal. So the patent is granted. Now you know that how important the science is. So we have to mention what is the example or what is the science that is behind the invention. So details of the invention to be performed well. So claims. Claims are the borders of the patent, and it is the important part of the patent. These claims are paramount importance in both patent prosecution in the patent office and patent litigation in the courts. Abstract. It should reflect the technical field of the invention with the existing technical problems within 150 words. The aim of the abstract to provide the better information to third parties. I'm moving to the next slide, complete patent application. So already we know that the patent is a techno-legal document. So is a techno-legal document describing and specifically claiming the invention, has a fixed anatomy. Scope of the patent is decided through claims. So claims is important. Kinds of patent or specification. There are two types of applications. One is provisional and the complete. If you are choosing provisional, then you will be given for a 12 months period time to file for a complete specification. The applicants from any engineering fields, it may be mechanical or it's electrical or electronics communication or whatever may be the engineering field, you can file for a provisional instead. The pharmaceutical companies or drug pharmaceuticals, they are specifically they are going to file for a provisional specification because they have formula for a medicine. After completion of 1 year, they can come into a conclusion that whether particular formula is treating such a disease in a good manner or not. If not, they will abandon the file. So provisional filing, if you are filing today, the provisional, you will be given 1 year time period. Within that, you have to file complete specification. So I'm moving to the next slide. So this is the life cycle of a patent application. So first you are going to file a patent application, whether it may be a provisional specification, otherwise it will be a complete specification. So I already said that if you are filing provisional, you have to keep in mind that you have only 12 months period. Within that, you have to file complete specification. After filing complete specification, it will be directly going to the publication after 18 months. So after 18 months, the government is publishing your patent application in patent journal. You can check these patent journals in the IPO website, that is www.ipindia.nac.in. So after publication, if you want your publication earlier, you don't want to wait for 18 months, then you can file a request for early publication also. There is a provision is that. So the next portion is pre-grant opposition, which is optional. So while publishing your patent application, anyone from any place who can see the publication, they can have an idea that that particular invention which is published may be their own patent. So they can file for a pre-grant opposition. If there is no pre-grant opposition, then the patent application is going to examination. During examination, the examiner points. There are two types of objections. One is technical and one is the formality checkup. Once the examination is over, your examination report is published to you. So first examination report, which is nothing but FER, is issued. So FER consisting of two types of objections. One is technical objection. Next one is formality objection. So you are given with a period of 9 months or grace period of 6 months. Within that, you have to file FER reply to the examination report. Once the reply satisfies the examiner, then patent grant will be given to you. Otherwise, a hearing will be there across the table. Yourself and the examiner have to discuss the matter and conclude the matter. So after final grant of the patent under section 43 and publication of the grant also appearing. So this is the full life cycle of a patent application. So I'm moving to the next slide. How we can assist an inventor. So during the search, has your idea been done already? So we are going to find prior art for your invention. The next step is consultation. After conducting the prior art search, we will give you a legal opinion, and if it is favorable for filing a patent, we offer a customized quote to you. And the third step is engaging and saving, reviewing our quality work and competitive offering, and we are going to continue our patent application filing. There are some basic forms like Form 1, Form 2, Form 3, Form 4, Form 5. There are plenty of applications are there through which we are going to file patent applications to you. So with this, I am concluding the portion of how we can file patent application. So I'm moving to the last. So here are.
Yeah, sorry.
So our contact details are here.
Okay, carry on.
Yeah. Thank you for one and all.
Thank you, sir. Thank you, Savi Rajan sir and Santi Lakshmi ma'am. The
Yeah.
participants, if you have any queries or clarification regarding today's webinar, you can just post in your chat box so that ma'am and sir can answer those questions.
Okay. There is no questions asked, no doubts asked. It's contact details again. Okay. Someone, Venkatesh Marimutu is asking, patent agent as a career. So Sauri will be the right person to answer this question. Sauri?
Yes, madam.
Yeah. Mr. Venkatesh Marimutu is asking
Okay.
about the career as a patent agent. So
Okay.
can you throw some light on this?
So he want to become a patent agent, right?
Patent agent, yeah.
Yes. Okay. So as I already told you that www.ipindia.nic.in is a government website. So in that you will have a notification that patent agent examination is there. Once you are clearing the examination, you will become a patent agent. I suggest you to join a company like Morgan Associate or All You Need, like that. You can have a better experience to face the examination. So only reading and getting paused in the examination will not be useful for you. That's all.
Any other questions, doubts? So shall we wind up? Krishna Kumar sir?
Yes, ma'am.
Shall we wind up?
Yes, ma'am. There is no more questions from the participants.
No
We can
more
wind up.
questions. Okay. I
The-
think there's no questions. If
I think
at
you can
all,
post
we
the
have
contact
There are some
details in
questions
chat
in the
box.
yes. So there are some questions in the Dropbox.
Okay. Where is it?
If the students is allowed to ask their questions, we are ready to give answers.
That's a question. If
Ah,
I
there
have
is
any
one
innovation
question.
before going to patent, shall we publish in any journal?
No, it is not advisable. There are one more question from Mr. PG Guruswamy Pandian, PRO. One second. My small question to clear from Madam, whether merely filing is considered as getting patent right, Madam? No, it is not. First, you have to file your patent application after conducting prior art search. If it is really patentable and it has inventiveness and industrial applicability, and it is novel, there is a chance for you to get the patent grant. Once you get the patent granted, you have the exclusive rights to make, sell, or use of your own inventions, and you can assign or license your invention to third parties for the lump sum amounts. So merely filing an application will not protect you, and at the same time, filing an application will give you the prior claiming your application and elder date. What is that, Sauri? You can claim elder data application. See, if some person comes with the same identical invention, if you file your application at the first instance, it will give you the elder data.
First priority. First priority.
The first
to
priority
that applicant.
will be enjoy. Yeah, you will be enjoying the first priority. On the priority basis, you will get a registration done. This is the answer for your query. I hope I have clarified to some extent. And any other queries?
I'm asking how much it will cost for filing a patent.
The cost for costing and other charges, you can contact us through mail or phone. We will be in a position to give you all the details regarding the timelines and charges and all. Any more doubts or questions?
Can you suggest some books?
Books and all, see, books and all can be registered under copyright because it's a literary work. As I said, the IPR protects protection for books and literary works are covered under copyright registration.
No, ma'am, I didn't ask about the copyright rights. Actually, I asked you to suggest some book for further references.
Oh, for further references, sorry, you will be use of
So you can.
suggest some books.
Okay, you can refer Patent Act 1970 is a book. This Patent Act is available freely in the website www.ipindia.nic.in.
Okay, sir. Thank you, sir.
Thank you.
Hello, madam.
Yeah, yes, sir.
Yeah, madam. If we want to invent something, how to know that if it is already patented or invented?
Yeah, that's why we have an option to conduct prior art search. While conducting prior art search, you will come to know what is the existing patent and what is the existing inventions and how your invention is different. I mean, different from the existing patents. For that reason only, we suggest to conduct prior art search, and it is not only a suggestion; it is a practice. It has to be done.
Yeah. Okay, fine.
Blessing Sam, he's asking how should we submit the report, FAR. Sorry, sir.
Okay.
You can handle this question.
Okay. So while replying to the examination report, you should take care about the date. So when your patent application is examined, and when the FER is issued, within 6 months of period, you have to file response to it. You can file your response through online or offline. So for filing the reply to the examination report, you can use www.ipindia.nic.in website. Otherwise, you can go to the office directly in person, which is located in Guindy, Chennai.
Vijay Sri, whom should I approach for a patent? You can approach a patent practitioners, or you can approach us if you like. So we will guide you how to protect your invention under a proper channel. Hariharan P, he asked, what's the difference between inventor and assignee for a patent? What are the rights and privileges which each have?
Yes, this is a good question.
Yeah.
So who is the applicant now? So if the inventor and himself is applicant, then all the patent rights will be going to the applicant only. So for example, I am saying Joseph is a person who is the applicant as well as he is the inventor, then the entire rights will be going to the Joseph only. And for example, another example, maybe TVS company. So TVS Motor Company is the applicant and the R&D peoples of the companies are inventors. Then the entire patent rights will be going to the company only, TVS Motors. So any other questions?
There is one more question, Rajashekar G. Why in India the patent law is not amended when sui generis by US is advantageous to us? Sorry, can you throw light on this?
Yes, sui generis.
Yeah, when sui generis by US is disadvantageous to us. Why in India the patent law is not amended?
No, but now I already told you that there is no world patent. So the patent act from one country to another country will differ always. While considering the drug patents, the US is charging more. While it is coming to India, India has one of the option that compulsory license. When you are going to give a medicine for 100 rupees, then if compulsory license is applied, then particular product will be available for rupees 10. So it might hinders the US investors. So there is a war between the patent act in US as well as in India. So God only knows.
Hope it's been clarified. Okay. Subramaniam, I am an associate professor. We offer the projects students. Does the intellectual property belongs to me or students or institutions? Can you read the question, Sauri?
Yes, ma'am.
That's a question from Mr. Subramaniam. He says that he is an associate professor and he do projects for his own ideas by students.
Okay.
So does the intellectual property belongs to him or to the students or to the institution?
Now, who wants the patent right? Either professor or students or the institution.
The idea is his own ideas.
His own idea. He wants to protect this idea for himself only. Then he may appear for the applicant and as well as inventor.
Okay.
Otherwise, if the institution is paying money to invent something, then the patent rights will be towards the institution only.
So the idea and the funding all matters.
Yes.
Okay. So any more questions? What are the guidelines for standards in each patent approval?
Sorry?
What are the guidelines for standards in each patent approval?
So as I already told you that your invention must have a novelty and inventive step and industrial applicability. These are the three main categories which will be fulfilled. Then your patent application will be granted.
Any questions? If you have any further questions, queries, or doubts, you may please contact us in the provided mail IDs. So you can send your doubts. Hope we will clarify all your doubts. As the time constraints, we have to wind up.
Thank you, ma'am. Thank you, Santi Lakshmi ma'am, and thank you, Sauri Rajan sir.
Yeah.
It was really a great session. And on behalf of Department of Mechanical Engineering, St. Joseph Institute of Technology, we would really be thankful and grateful for your time which you spend with the students and academic communities.
Yeah. Once again, I insist, please be smart enough to use your invention productively and thereby protecting yourself and your invention through a proper channel. And once again, my heartfelt gratitude to the management of St. Joseph Group of Institutions. And thank you, staffs and students, for showing your interest, patience, and cooperation. Stay safe and blessed. Thank you all. Thank you.
One more thing, ma'am, you
Thank you.
can just drop me a mail with your contact details.